if I had been operating the chess clock, which operates in some procedures, I'm afraid Mr. Berry would only have 20 minutes left. Obviously, that won't be enough for him to cover the ground he needs to cover, but perhaps we could just bear in mind the position as we go through the afternoon.
My Lord, I obviously was aware of the time clock point, and the appeal was very important. It was important Mr. Berry had the opportunity to say everything he wanted to say in his reply, and I've discussed the matter with Mr. Hayne, who's arguing election, and I'm going to endeavour to ensure I'll be finished by 3:15, so he gets a full crack at it.
Well, that's very helpful.
Even if that contains my reply.
Very, very good. Well, we're grateful to you for being so cooperative. Yes, Mr. Galcum, carry on.
Thank you, my Lord. Just to recap very quickly, and I should say that I hope to be very brief in what I've got left to say. Just to recap, we've gone from a regime where we moved from permission being required in this sort of situation to one where permission is not required. We've seen in the case of Singh that exactly the same process happened, the same transition happened, and the merits test was held still to survive that transition. But now I'd like to take the court, please, to the decision of the Privy Council in Q8 Asia Bank, which is in Authorities, Volume 1, Tab 22, page 386. And if I could ask the court, please, to come to page 403. Page 403. And what I endeavour to show the court is that exactly the same transition from a permission regime which required or involved a merits threshold to a regime where there was no permission required happened exactly the same way in New Zealand. If I could invite the court to have a look at line G, and there's a provision called Rule 48. Now that's a provision you can see from the first two lines of Rule 48, provides for various circumstances in which service out can be done with leave, and that is clearly subject to a merits test, as we can see on the next page at line D. And there's a reference to another rule on page 404, this is at line D, where there's Rule 50, which says that an affidavit supporting evidence is required for permission to serve out. And at line E, just below, Lord Lowry says, and I'll quote the last sentence, he says that Rule 50 was comprehensive and required in all cases what might be called an affidavit of merits. So under the old rule in New Zealand, where permission to serve out was required, it was subject to a merits test. I could ask the court, please, to look back to page 403 now. Line D, we see the new rule being set out by the Privy Council. And the new rule is called Rule 219, and you can see from the first line, Rule 219, it says when service out can be permitted without leave. And I'll just emphasise there that there's no reference, of course, to a merits test in Rule 219. Now, if I could ask the court, please, to come to the crux of what the Privy Council was asked, or the Privy Council's decision. And the Privy Council was grappling with exactly the same issue that we are grappling with now, in the sense that the judge at first instance, Mr. Justice Henry at first instance in the New Zealand High Court, had held that the change from a regime where leave was required to one where no leave was required was destructive of the merits test, a merits threshold, and that the sole issue that remained was whether there was a good arguable case that what we call one of the gateways remained open. And if I could ask the court, please, to look at page 411, where at line C, the Privy Council upholds the New Zealand Court of Appeal in overruling the first instance judge. And the critical text is the text at line D, where the court says this: the court retains a discretion to set aside service, and these are the vital words, on the same principles as governed the granting of leave under the former Rule 48 and the setting aside of service before 1986. That's when the permission regime was switched to one that didn't require permission. Could I ask the court, please, to come to page 413. At page 413, I won't ask the court to read everything that's said here, but where the red line is at 413, continuing on to 414, there's an extensive extract from the case of Singh, decided by the Court of Appeal of Ontario, which I've already shown the court. And they're setting out their understanding and interpretation of the judgment. In fact, the judgment is regarded as sufficiently significant that there's another long extract, again marked with red line, on page 415, 416. This is a quote in extenso from Mr. Justice Arnott in the Court of Appeal. And the vital holding of the Privy Council, which is very compact, comes on page 416. There's only two sentences here that I need from this page. The first one, and on page 416, is at line B, where their lordships say, having summarised the Singh case, they say, their lordships find these observations to be strong and convincing arguments in support of the approach of the New Zealand Court of Appeal, holding that there's still a residual discretion on the part of the court to set aside a service to decline jurisdiction on merits-based grounds. And then also, if I could take the court, please, to what's said at line F. This is the final part of the Privy Council's decision on this particular issue in the appeal. At line F, the final sentence here, that rule and Rule 219 is the new rule that says permission is not required, have not abrogated the court's inherent jurisdiction to decline, the court's inherent discretion to decline jurisdiction. Now, we the exporters say that's as clear as could possibly be made by the Privy Council unanimously. Incidentally, judgment in this case was handed down in advance with reasons to follow, which might be taken as an indication about how clear the Privy Council thought the matter. And they have held that where there is this shift from a system where permission is required to one where permission is not, it is just a procedural streamlining of what has happened, and that it doesn't remove the ability of the court to determine whether it will exercise jurisdiction. And in my respectful submission, this court should, of course, unless there's very good reasons, follow, or at least place very great weight on what their lordship said.
What is the purpose of a merits test in a case where there is entitlement to serve out of the jurisdiction? I can see that if you need permission, then a merits test is sensible, because a judge or a master will look at it and think, well, there is at least something in this case on the merits which justifies bringing somebody here. But that is still subject to arguments about forum convenience.
Yes.
For example, the mere fact you get through a gateway doesn't mean that you are entitled to establish jurisdiction, because there's still that point to be got over. But if you don't have a merits test and somebody comes here and it is otherwise a convenient forum, why do you need a merits test when there is the perfectly suitable alternative remedy of striking it out under summary judgment?
My Lord,
particularly where the merits test is now, which maybe it wasn't always, the same as the summary judgment test.
My Lord, that's a point that I was going to come to, and it might actually be convenient if I turn to that now. This, of course, was not a point that occurred to their lordships in the Privy Council, and it would have been a point that would have been available to them. and they haven't alighted upon that particular point. That's one thing that can be said. But the other point that can be said in answer to what my Lord has said, which is that it's important to ask what's the purpose of the merits test. And there's a passage in the White Book that I won't ask my Lord Court to turn to, but I'll just read it out. It's very short from the White Book. It says this: the purpose of the merits test, it's at page 306 of the current edition of the White Book, just for the transcript. The editors of the White Book say this: the court should not subject a foreign litigant to proceedings which the defendant would be entitled to have summarily dismissed. So there's a clear policy imperative that underpins the merits test, which is to the effect that it's not adequate to deal with cases that wouldn't survive summary judgment by striking them out or entering summary judgment at a later stage. That's the rationale for the merits test. And that rationale applies regardless of the jurisdictional basis on which the claimant is endeavouring to obtain jurisdiction. The point of principle is operative regardless, in other words, of the jurisdictional hook that the claimant is endeavouring to use. And that, in my respectful submission, is the answer to that point. If the point was good, it would mean there should be no merits test anyway under any situation, because there would always be the fallback of the possibility to strike out or enter summary judgment. In my respectful submission, I'd also ask the court to look at what the Civil Procedure Rules Committee has said, which we say is instructive, very strongly supportive of our position on the proper interpretation of CPR 6.33. And if I could ask the court, please, to turn to Authorities Bundle 3. It's at tab 54. It's at page 1143. It's at page 1143.
Sorry, did you say tab 54?
Tab 54, my lady, yes. Tab 54, and it's the critical paragraphs here, paragraphs 44 and 45. And what the Rules Committee is doing here is discussing this is the recommendation that led to the change in the permission regime. And the private International Law Committee had recommended that there be this change that was made. You'll see a reference later in paragraph 44 to 6.332C. The eventual numbering has ended up changing. Nothing turns on it. That explains why there's a reference to 2C. But the critical paragraph is 45, where they say this. Say the purpose of the changes is that it will give significant reassurance to the legal profession and wider business community and instill confidence in businesses to continue to choose jurisdiction clauses in favour of the courts of England and Wales. And then these are the vital words: by eliminating a preliminary step which adds cost and delay. It would remain possible for defendants to challenge the court's jurisdiction at a later change. Now, if there were any suggestion, in fact it is the suggestion that our opponents make and invite the court to accept, that there's some radical change that's being affected here, whereby the merits test is dropping out, one would expect to see that discussed by the Rules Committee. There's no indication of that whatsoever. Instead, what the Rules Committee is saying exactly what the Court of Appeal of Ontario has said, which is that this is simply a streamlining of the procedure aimed at reducing cost and delay by removing the initial step to establish that would be required for service out on one of the gateways under 6B. We say that powerfully supports our interpretation of CPR 6.33. final point that will trouble the court with is what the High Court has said on several occasions about CPR 6.332b little b. Now, I won't take up the court's time by taking the court to each of the individual judgments. They are set out in our supplementary skeleton argument. I'll give the court the page reference if I can, please. It's paragraphs 12 and 13 of our supplementary skeleton, which is at 418, page 197. And there's a number of decisions that proceed on the footing that the merits test remains fully applicable to service out under 6.332b. And that, I should say, in the case of some of these cases, is without having been taken to the judgment in Singh and the judgment in Q8. They've independently reached the view that that is right. The cases are in re banco. As I said, I won't take the court to the judgments in the interest of time. In re banco, the court was in fact shown Q8, and Mr. Justice Lightman says he's clearly satisfied that there is still a residual discretion. IBM is a decision of Mr. Justice Waxman, who proceeds on the footing that there is a merits test applicable to CPR 6.33. There is a decision of Master Stevens of Pantheon, where Master Stevens says there's a judicial question mark hovering over this issue, but there's no indication that he's been taken to the authorities which I've taken the court, which might explain why he considers the judicial question mark still remains. There's a judgment also of Mr. Justice Bright in Magomedov, who has a footnote, which is in our skeleton, where he says the court always has, even where service out is as of right here, as under section CPR 6.33, even where service out is of right, he assumes and proceeds on the basis that there is still always a residual discretion inherent in the court's jurisdiction. I can't assist the court any further. Those are my submissions on that aspect of the respondent's notice.
Thank you very much indeed.
Right, please, my lord, if I could deal with the substance of it, and I'll be as brief as I possibly can. Can I start by showing you the respondent's notice itself? I don't think we've looked at it. No reason we should have done. It's in the core bundle at tab 10, page 76. And section 6, grounds for appeal or for upholding the order. We say we want to uphold the order on additional grounds, and the issue, or the reason is because the appellant elected and or is to be taken to have elected to treat the first defendant as its debtor. It's bound by that election and or by the rule in Kendall and Hamilton. So effectively we put it, and I'll try and articulate why in two ways. We rely upon the rule in Kendall and Hamilton, probably misnamed, but we'll come on to that. And we also rely upon election in a sense which I might call vanilla election, because the word's used, as you may or may not know, in a variety of ways. And we mean classic know your rights election is the vanilla type, and that we rely on that too. So Kendall and Hamilton and vanilla election. And I'm going to try and do this by, and there's a myriad of cases, and it's rather difficult to know. You could argue this all sorts of different ways, but what I'm going to try and do is to identify the propositions of law that we rely upon, and then I'm going to apply them to the facts. So there are a number of propositions of law, 8 of which I'm going to try and articulate, on which we rely. The first proposition is this, and it's the starting point, is that the liability of an agent and an undisclosed principal under a contract is alternative. And what that means is that there is only one liability. That's the way Miss Dias QC, as she then was, put it in the Taylor case. And it's that fundamental fact that engages the doctrine of election. And we know from Lord Sumption, judgment in the Playboy case, that he added as a 6th proposition to the classic 5 propositions set out in the Privy Council case. The 6th, namely, the third party must elect between the agent or the principal. The second proposition is that suing an agent to judgment will automatically release the principal, even in cases where the third party is ignorant of the principal's existence. Now that is known as the rule in Kendall and Hamilton. But as Miss Dias correctly said in the Taylor case, it should probably best be called the rule in Priestley and Fernie. And I just show you briefly why she said that, or why I'm saying that, sorry. And if I can take you to Taylor, it's in bundle 2 of the authorities, tab 40. Paragraphs 202, 203. Perhaps one needs to look at 198 actually, just to see what the context is. So begin at 779. She's describing this section of her judgment as being the ratio of Kendall versus Hamilton. She sets out the facts. Paragraph 202, she says, the clear ratio of the decision was accordingly that Hamilton was released from liability on the basis that he was a joint contractor with Wilson and Maclay, and that judgment against them exhausted the cause of action against him. In the circumstances, to describe the principle that judgment against an agent releases an undisclosed principle, as the rule in Kendall's case, appears something of a misnomer, although she'll continue to refer to it as such for the purposes of exposition. Well, we've referred to it as such as well in our Respondents' notice. But the reality is, as the basis of the rule, she goes on to say, we submit correctly. The basis of the rule, nonetheless, the rule does undoubtedly exist. Lord Cairns regarded it as beyond doubt, and it clearly appears from the only authority to which he referred in support of the proposition, namely Priestley versus Fernie. So, just to reiterate my second proposition, it is that suing an agent to judgment will release automatically the principal, even if the third party is ignorant of the principal's existence, and that rule is commonly known as the rule in Kendall and Hamilton, but in fact is actually to be derived from Priestley versus Fernie. So that's the rule. Now, the key part of my argument is the third proposition, which is the, or at least a basis for the rule in Priestley versus Fernie, is that as soon as judgment is entered against the agent, the undisclosed principal becomes liable to indemnify the agent. So the reason why the principal is released from liability to the third party is because once judgment is entered against the agent, the undisclosed principal becomes liable to indemnify the agent. And once the principal is liable to indemnify the agent, he can no longer be liable to the third party. And just let me try and show you the law I rely upon for that proposition. And I start, of course, with Priestley itself, the seminal decision on this rule, and the judgment of Lord Bramwell, which is in Bundle Authorities Bundle 1, tab 1, page 9. This is a case about a master who entered into a contract without disclosing the existence of a ship owner, and Lord Bramwell, and he went to prison for the debt, and then they sought to go after the owner as an undisclosed principal. And Lord Bramwell said they could, or Baron Bramwell said they couldn't, and he says so on page 9, first paragraph. We are of opinion our judgment should be for the defendant. If this were an ordinary case of principal and agent, where the agent, having made a contract in his own name, has been sued on it to judgment, there can be no doubt that no second action would be maintainable against the principal. The very expression that where a contract is so made the contractee has an election to sue agent or principal, supposes he can only sue one of them, that is to say, sue to judgment. And then he goes on to explain, for it may be that an action against one might be discontinued and a fresh action, fresh proceedings may be taken against the other, so that there is an abundance of authority to show that where the situation of the principal is altered by dealings with the agent as principal, the former is no longer subject to an action. But this is the case here. The defendants may or may not be liable to indemnify the master in respect of his costs or his imprisonment, but they are clearly liable to him or his estate in respect of the damages recovered against him, and proceedings might have been taken against them as soon as judgment was recovered against the master, and before any payment by or execution against them. They are now therefore under a liability to the master or his estate to the extent of the whole claim, and yet it is sought to bring them under a fresh liability for that to the plaintiffs. So that's the way it's put there. And then in Kendall itself, Earl Cairns reiterates that rationale for the rule, and we'll see that in his judgment at tab 5 of the same bundle in Kendall and Hamilton. And the relevant passage begins at page 36 and runs through to page 37. And it begins between the hole punches. Now, I take it to be clear that when the agent contracts in his own name for an undisclosed principal, the person with whom he contracts may sue the agent, or he may sue the principal. But if he sues the agent and recovers judgment, he cannot afterwards sue the principal, even though the judgment does not result in satisfaction of the debt. If any authority for that proposition is needed, it comes from Priestley. But the reasons why this must be the case are, I think, obvious. It would be clearly contrary to every principle of justice that the creditor, who had seen and known and dealt with and given credit to the agent, should be driven to sue the principal if he does not wish to sue him, and on the other hand, be equally contrary to justice that the creditor, on discovering the principal, who really has the benefit of the loan, should be prevented suing him if he wishes to do so. But it be no less contrary to justice that the creditor should be able to sue first the agent and then the principal when there was no contract, when it was never in the intention of any of the parties that he should do so. Again, in an action were brought and judgment recovered against the agent, he, the agent, would have a right of action for indemnity against his principal, while if the principal were liable also to be sued, he would be vexed with a double action. So that, in my submission, reflects the basis of the rule that's set out in Lord Bramwell's speech in Priestley in exactly the same way, and it's made, in my submission, even clearer in a Scottish case called Logan and Schult, which is in the same bundle at tab 9, beginning at page 152, Lord Stormoth Darling's judgment from a case from 1903. And the relevant passage is on 153 of the bundle. And it's the middle of the page on 153 in the left-hand column. And it's, the passage I want to pick up is after the semicolon where he says, but it is clearly the law. But it is clearly the law that if he proceeds, this is the third party, if the third party proceeds against one of the parties and sues him to judgment, that is held as conclusive on the question of election. In the ordinary case, that rests upon the plain ground that by suing the agent, let us suppose to judgment, he thereby gives him a claim, him being the agent, a claim of reimbursement against the principal, and the principal is not to be exposed to an action both at the instance of his agent and at the instance of the disperser who...
He says it's conclusive on the question of election. That's not really what he means, is it?
Well,
what he really means is it has the effect, whether you know about it or intend it or not, of extinguishing the right against the principal.
Quite. My lord is absolutely right. And if I were to go through the authorities one by one, there's a myriad of cases where the word election is used in different ways, which is clearly inaccurate. And what I'm trying to do, and what we sort of do in our response notice, is distill what the principle in Kendall and Hamilton is, on the one hand. And although some of the cases talk about election in that context, my submission is a distinct rule with a different rationale, which I've sought to identify, and contrast that with what I call vanilla election, Kanchenjunga style, which we also rely upon, but is a different concept than Priestley and Kendall and Hamilton. Kendall and Hamilton.
Which concept did Lord Sumption have in mind when he talked about election?
Well, they both lead to the same consequence, that when you, that case refers to the fact that taking judgment is the clearest form of election. So, in a sense, they're related. But anyway, that's a dilemma. A fair point, my lord. I think what Lord Sumption was seeking to capture in that context was the fact that it's an alternative liability. There can only be one liability, rather than the doctrinal issue as to what the true juridical basis of the various rules are, which is what I'm trying to help you with. But I do accept the cases are diverse in the way in which they use the word election. And certainly in my analysis, I'm trying to bring, as best I can, sense to it. And what I'm at the moment seeking to do is to identify what the rationale and basis of the rule in Priestley is, which doesn't depend on knowledge and can apply even if you don't even know about the existence of the principle. If you enter a judgment against the agent, that triggers the right of indemnity against the principal, and that automatically releases the principal from liability to the third party.
Right. Well, your Proposition 3 doesn't get you home because there isn't a judgment against the agent.
No, that's why I need Proposition 4, which I'm about to come to.
Yes.
Proposition 4. In addition to a judgment, an arbitration award, this is what I might call my Eagle Star or Norwich Union point, is a classic point of English law, which is, in addition to a judgment, an arbitration award against an agent, or an agreement, a settlement, or some form of agreement between the third party and the agent, all have the same legal effect, which is that they crystallise the liability of the agent and thereby immediately make the third party liable to indemnify, the principal liable to indemnify the agent. So in other words, what I'm saying is that the rationale for the Priestley rule is liability crystallises, triggers the obligation to indemnify the agent, releases the principal to the third party. That's the basis of the rule, and I'm saying it has exactly the same application when the liability of the agent to the third party crystallises by way of judgment, award, or settlement, which is a classic Norwich Union ways of putting when the obligation to indemnify in English law arises. That's when the liability crystallises. Now, it's fair to say we haven't found a case where settlement, there has been a settlement. Bizarrely, this is bizarre, but we're not aware of a case. At least we found one in Philadelphia, but it was so badly reasoned. We didn't even bother putting it in the bundle. There's too many there already. But we haven't found it, it's fair to say we haven't found it, there's no case we're aware of where a settlement has happened with the principal or the agent, and that's had the consequence of releasing, but just not being considered, as far as we're aware. But anyway, my principle, my lord, is based upon what we would submit, or my proposition is based upon what we would submit is self-evident principles. It's not difficult. So those are the four major propositions of law I rely upon, and I'll seek to say why they're relevant when we get to the facts. The fifth is...
Could I just ask a question about
Yes.
the second? If there was an agreement between the third party and the agent accepted liability, but on, let's say, expressly reserving the rights of the third party to go against the principal, would that result in have the same result?
All I would say is possibly, and the reason I say that is because it's not necessarily a part of my case, because there is no reservation, and that's what makes it unequivocal. It could be, if you're looking at it through the eyes of election, that would create some lack of unequivocalness, which could be relevant. But for the Priestley point, it could make a difference. I'm not trying to answer the question, could make a difference, but it's not this case, and therefore I'm very much aware, and we've got the Gladman case in the bundles, when it comes to joint tortfeasors, let's say, if you settle with one and you make a reservation, then you're not caught by the unwary trap, as Lord Justice Steyn called it once. But if you don't make a reservation, you are. Now, it may be different when we're talking about alternative liability, which is what we have here, and there's only one liability rather than a joint liability. So that that may be a difference. But as I say, that question doesn't arise here, we say, because there is no reservation at all anywhere, either in the proof that was lodged or indeed in the agreement that was reached with the liquidators, which I'll come on to. So that's my fourth proposition. The fifth proposition law is this, that there are a series of cases of high authority that have established that intentionally seeking to prove a debt in the insolvency of either the undisclosed principal or the agent can amount to an irrevocable election to treat that party as their debtor and release that other party from liability. And the most important cases in support of that proposition are the McCure case, which is in bundle A1, the Scarf and Jardine case, which is also in bundle 1, tab 6, Lord Blackburn in particular, and the Logan case, which is a Scottish case we've already looked at. Now, what sense do we make of that? It is not easy to try and make sense of where those cases fit into the election analysis, but I'll set out what my case is.
Have we moved off the rule?
We've moved. Priestley, the Kendall-Hamilton Priestley point is actually ultimately a very simple one.
Yeah, you're not relying on the proof for that purpose.
No, the proof doesn't in itself. It's just a unilateral act on the part of the third party. We say it's highly relevant because it's the third party asserting unequivocally that the debtor owes him a debt, and therefore we say it's an unequivocal treatment of the agent as the debtor, and that's in itself sufficient to amount to election. I'm just trying to put it into the conceptual context of where it fits with either plain vanilla election and, on the other hand, Priestley. And I'm saying this is a separate point from Priestley. Priestley is self-contained. It arises from the fact that once you have an obligation on the principal to indemnify the agent, by definition, he is thereby released from his liability to the third party.
So if I got this right, your primary submission is that your first four propositions get you home.
Yes.
And now you're dealing with an alternative route, more properly called election.
My lord, that's right. Yes,
Okay.
sorry,
I
didn't make that quite clear. That's quite right.
Yep.
I get four. In my respectful submission, it gets me home because when we look at what happened in the New Zealand proceedings, there wasn't a judgment. There's no question. It's not a merger here. We're not talking about that. We're talking about the fact that there was an agreement, essentially, we would submit, an agreement to discontinue having got a full admission of liability from the liquidators, and we submit that has the same effect as a judgment, not in terms of res judicata or merger or any of those weird and wonderful doctrines, because it triggers the obligation to indemnify, which is the true rationale for the rule in Priestley, as we've seen from Priestley itself, from Lord Cairns, and from the Logan case. So yes, my lord, I'm now on 5, and this is right. It seems to me it has to be, although the word election is used in a variety of ways, even in Jardine, which is hard to understand. In my respectful submission, those cases are in fact properly to be understood as, if they're applicable at all, as an irrevocable election based upon classic, unequivocal acts with knowledge of the facts, giving rise to the right to elect. So, if you're ignorant, for example, of the existence of the principle, then there can't be an election. So my sixth proposition, and this is probably hopefully self-evident and uncontroversial, is that for conduct to amount to an election, there must be an unequivocal act to treat the agent as the debtor, made in circumstances where the third party has knowledge of the facts giving rise his right to elect between the liability of the agent and the liability of the principal. So, for there to be an election, the relevant ingredients are there has to be an unequivocal act to treat one party as the debtor, and that has to happen when the third party has knowledge of the facts giving rise to the right to elect. And I'm going to concede a point here, at least for present purposes, which there's a big debate about Payman and Jani and whether or not for the purpose of election you just have to know the facts or you have to know your legal rights that arise out of the facts. I'm going to concede for the purpose of this argument that you have to know both the facts and the legal consequences of making the election. But the reason I'm happy to do that is because what we know is that in 2023, Berge had the benefit of some of the very best legal advice in the world. They had Holman HFWs, it's now known, HFWs international offices advising them. They also had the services of local lawyers and solicitors acting for them in New Zealand. So they were fully geared up with legal advice of the highest quality. And the significance of that is the necessary knowledge to make an election will be inferred where the third party has the benefit of legal advice and has already pleaded a case of undisclosed agency. And the authority I rely upon for that proposition is the Taylor case, a decision of Miss Justice Dias, as she then was. Sorry, not Miss Justice, Miss Julia Dias, QC as she then was. And that's at tab 40 of bundle, authorities bundle 2. And it's paragraphs 242. I haven't explained this case, which apologies, and that's simply because of the time, but just to put it in context. She dealt with the case on the basis of both the separate Kendall and Hamilton issue, which she found in favour of applying, and then she also, Obiter, dealt with what one might call a vanilla election, which begins at begins at 232,788. And she deals with, so it is fair to say this is Obiter in the sense that she says, given the conclusions above, the question of election does not arise, so it's been fully argued. Therefore, I express my opinion on it briefly. All I would say is when the case got to the Court of Appeal, seemed to think that her findings on election were conclusive, and they didn't actually give the merits of that argument any consideration because they found they dismissed the appeal on other grounds. But there's no reason for thinking that there was any criticism of what Ms. Dias said in this section of her judgment. And I want to pick it up at paragraph 242. So what was being said is that conduct took place in 2018, which was said to amount to an election because steps were being taken to, more than preliminary steps were being taken towards the enforcement of a judgment against the agent. The judgment itself had not been an election because it was entered into without knowledge of the principal. So we were looking for further conduct at a later date, which could be said to be the adoption of the agent as unequivocal adoption of the agent as the debtor. And the conduct relied upon was what happened in 2018. You see that from 240, 241. But they're just points on the facts. The key point of principle is what we get out of 242 and also actually out of 244. But 244 is important. 242 is the most important in terms of knowledge. Because by October 2017, Mr. Taylor had already pleaded his case on undisclosed agency. So in other words, in England, regardless of what they were doing in Monaco, in England they pleaded their case of there being an undisclosed principal. And then she says, there can therefore be no doubt that he knew the relevant facts, giving rise to his right to elect between the liability of the original defendants and the additional defendants. He had the benefit of legal advice from his English solicitors. In my judgment, they could reasonably have been expected to have advised him of the consequences of continuing to pursue his remedies based on the default judgment. There is clear authority at Court of Appeal level that the mere commencement of proceedings with knowledge of the agency is a strong prima facie case of an election. And the steps taken here went much further than that.
What is the case referred to in the footnote?
Well,
you don't have the footnote.
I don't think we have the footnote, which I'm apologies. Does anybody know? Okay. We're going to look. When I read that, I thought to myself, actually, I would have said House of Lords, because Lord Blackburn goes out of his way, probably goes to an extraordinary length in Scarf and Jardine to say what can amount to an election. But so I think, if anything, if you would, I would suggest that I would replace that with clear authority at House of Lords level. But we'll find out what footnote 5 is. But actually, that sentence I don't really rely upon. The point I'm really relying upon is the inference we know from other cases that can be drawn in relation to knowledge when parties have got sophisticated legal advice at their disposal. I also want to just deal with one other point. I don't know whether my little friend takes it, but it arises out of paragraph 244, which the argument against there being an election being run was, well, the question as to who was agent and who was principal is still in debate, it's still in dispute. So you can't have an election when the point hasn't been finally resolved. And Miss Dias rejects that argument. She says, Mr. Ramsden argued that no question of election could properly arise whether the existence of the underlying agency was a matter of dispute. However, I agree with Mr. Ashworth that this is a risk the claimant took. This was a case like Balgobin or Pendleton, where only one defendant or the other could be liable depending on the facts. In this case, the original defendants would always have been liable to Mr. Taylor, whether or not the agency was ultimately established, and it was therefore always open to him to elect to look only to them. If he wanted to preserve his options, the correct course would have been for him to apply to set aside the default judgment so that he could pursue all of the defendants in one set of proceedings.
Is that your answer to Mr. Berry's or perhaps Mr. Haynes' point that they may have known something, but they didn't know all the facts? In particular, they didn't know about the Address Commission.
Well, my lord, they didn't. That level of detail goes way beyond what is required in order to know you have a principal and an agent and have to choose to elect between them. The agent is what the learned judge in that case is saying is that the agent is always going to be liable, whether or not you've got this benefit of a godsend, of a gift of being able to find somebody in the shadows. And if you elect to take the person in the floodlight as your debtor, that's the choice you've made and you start with it, even if there's some uncertainty as to whether or not somebody is in the shadows. That's what she's, in my respectful submission, what she's saying. And the idea that the level of detail you have to know for the purpose of an election arising from unequivocal conduct whereby you adopt one party as your debtor is my submission wrong. What you have to know is that the fact there is potentially a principle behind the agent and that the consequences of choosing to treat one unequivocally as your debtor releases the other. Those are the only facts you need to know in my respectful submission. And then, final proposition of law is that some of the commentators, there's quite a lot of articles, suggestions saying this is a bit of a technical defence. It's a bit like the trap for the unwary, as it's called in the context of the Gladman rule. And you might think, well, is this fair? I mean, is this a fair rule? And in my submission, it is. Even though it may appear a technical trap, in fact, it is fair. And the reason it's fair is, in my submission, spelled out most clearly by Lord Blackburn, and indeed by Lord Justice Longmore. We'll look at what Lord Justice Longmore said, but most clearly by Lord Blackburn in Kendall and Hamilton itself. And can I remind you what he said? It's at bundle 1 of the authorities, at tab 5. And the relevant page of the bundle is 66, I believe. So it's Lord Blackburn's speech. Of course, Lord Blackburn then goes on to make a major speech in Scarf and Jardine out of interest. But anyway, we're dealing here with Kendall and Hamilton, and the first way I put our respondents' notice. And it's the middle of the page on page 66, which I rely upon. And he's saying, I do not think the defence a meritorious one. So he's saying the election defence, not a meritorious one. But I think in the present case there is no great hardship. The plaintiffs had a right of recourse against Hamilton, for which they never bargained. But they did nothing inequitable in taking advantage of that which the law gave them. They have destroyed that remedy by taking a judgment against persons who turn out to be insolvent. I do not see that Hamilton does anything inequitable in taking advantage of the defence which the law gives him. The plaintiffs got a right by operation of law without any merits of their own, by what, as far as regards them, was pure good luck. They have lost it by what was no fault of theirs, but was, as far as they were concerned, pure bad luck. They don't bargain for this undisclosed principle. It's a windfall. And if they lose their windfall, I'm in no more or less meritorious position taking advantage of it. And it chimes with what Lord Justice Longmore said, even in our more modern world of the 21st century in Ladman, which I think is in your Supplemental Authorities bundle. At tab 3. This is a case where Lord Justice Briggs, with the other members of the court agreeing, applied the rule that there's a release in the event of a settlement with one joint tortfeasor without any, let's go back to my Lord Justice Zacaroli's point, without any reservation. But one of the points was that, well, Lord Justice Stainer said this is a trap for the unwary, it's not a very attractive defence. And Lord Justice Longmore does deal with that in his judgment, which is at page 49 of the bundle, paragraphs 84 to 85. So I only add that this provides an opportunity to assess the value of the much criticised rule, the release of one joint tortfeasor, releasing all other tortfeasors. One would see that the rule is a trap for the unwary. One means by unwary an unrepresented litigant. But in a case like the present, in which commercial firms or companies are represented by sophisticated legal teams, that consideration is much less powerful. Well, in my submission, in the context of this case, given it's an undisclosed principal case, for the reasons Lord Blackburn gives, it actually wholly neutral. So those are the principles of
Can I just
law.
ask this? Because
Yes.
Kendall and Hamilton is obviously a case of judgment.
Yes.
Different point. I don't think you go so far as to say that commencing proceedings against the agent is an election. It can be. And you can avoid that by starting a set of proceedings against both. Why can't you avoid that by starting a set of proceedings against one and another set of proceedings against the other at the same time, or intimating that you're going to do that in the coming days? None of those would be unequivocal acts of election.
I think that's right, my lord. I haven't, but there is dicta I could rely upon. In fact, that's what I think Lord Julia Dias was referring to in that passage with the footnote, where you could say that just starting proceedings is an unequivocal election. I don't think that's right. And in fact, funny enough, the very first case, Baron Bramwell in Priestley says, sue, but sue to judgment. He says you can always discontinue. The normal rule about discontinuance is, of course, you don't lose, there's no res judicata. There's no destruction of the cause of action by discontinuance. So you can just discontinue, don't lose anything, there's no merger there. Obviously, we're not in that. We do have a discontinuance, but that could be a bit of a red herring, because the reality is what matters is the agreement that led to the discontinuance, an agreed discontinuance because of the admission. So we're in the agreement territory, not the order, judgment, res judicata, merger, all those strange doctrines. They don't matter here.
But are you not relying on the vanilla election?
Well, I am. I'm relying upon vanilla election in the what they did in the not in the commencing the suit in either New Zealand or in England per se. It's the proof serving the proof in the way they did in May of 2023, having started proceedings in New Zealand, having amended their pleading in England in February to plead a case of undisclosed principle. So they've done all that by May. They get to May 2023 and they put their proof in to the liquidators. And we can look at that. I need to look at it now because it's a key part of my case on the facts. They put their proof in in May 2023, months after they've pleaded the case in England, and it's at Supplemental Bundle 2, tab 50. Tab 50. And my submission is quite a remarkable document in a number of ways. Well, the first thing to note about it starts at tab 50. This is the covering message. One thing to note, it comes from Nicholas Poindexter, who's the chief partner in charge of the whole thing. So it's not. So it's the people at the heart of the matter. They're also the solicitors, although they're based in the China office. They're also the solicitors have been managing the case. New Zealand, England, China. They put in the claim form. You see the claim form itself at page 335. A creditor claim under section 304 of the Companies Act. And you'll see it's signed. It's for the full 6571-18355. The losses claimed in relation to both the Cosmos Harmony and the Index. You'll see the warning in bold in the middle. It's an offence under section 304 to make or authorise the making of claimants misleading in a material particular, knowing it to be false or misleading, or omit or authorise the omission from a claim of any matter, knowing that omission makes the claim false or misleading in a particular material particular. And then over the page at 336, you'll see, please see the claim summary and supporting documents enclosed with this claim form. And then we get what is quite a remarkable document. 25th of May 2023. And this is the key document I rely upon, page 337 to 339. I mean, it's not what it says, sorry, that I'm relying on, it's what it doesn't say. Because the only thing it says is that shipping is liable for the full amount. It doesn't say, oh, and by the way, we're suing shipping and we're suing, well, although there's an automatic stay, but now we've joined in some principles into the English action. So, you know, maybe we should apply for the stay in England to be lifted and this can be dealt with together. They only mention the English proceedings. They don't mention the fact they've pleaded case of undisclosed principle.
Sorry, so for this, to get the time up, at this stage, they've already begun proceedings against the principal.
Yes. Yes.
Yeah. So they now, and they've also begun proceedings against the agent in New Zealand.
And in England. They've sued the agent in England and in New Zealand.
They then submit a proof in the liquidation in New Zealand, which is a proof at the liquidation of the agent.
Yes.
So the only claim they could assert there is the claim against the agent.
Yes. Yeah. That's absolutely true. Yeah. But what they don't do is treat their assertion of the agent's liability, which there can only be one liability. Because once the liability of the agent is established, that releases the principle. There can only be one liability. They don't qualify in any way that this assertion of there being one liability on the part of the agent could be subject to the fact that there are extant proceedings in England, or indeed elsewhere in England, whereby it's also said that there should be a claim against the principal. And why that's important is because having put this proof in, it's just pure happenstance, unless something's been going on behind the scenes we're not aware of, but it could be pure happenstance. They haven't been paid a dividend yet, if that's right. I mean, last
We
July,
don't know that, do we?
well, we don't. We think no, we don't know. There's no evidence about it, but I think they've managed to avoid
instructions. I can say no dividend has been paid.
But you're leaping forward 2 stages there, because before the dividend's paid, there has to be an acceptance of the claim.
True.
That's your admission point.
But that's done by the liquidator. No, what I was trying to say is no further action will be required from the third-party creditor to lead to a dividend being received. So he's done everything he needs to do. The liquidator obviously has to decide whether to accept the claim, but that's a matter for him. That's why in some of the cases there's dicta saying that serving a proof is efficient the same as a judgment. In fact, there is a case to that effect. I could rely on it. That's the Scottish case, the Logan case. He goes as far as saying, having put the proof in, he's done as much as he can, and you should treat that as being the equivalent of a judgment. Now, I don't put my case that high, but there is authority that would allow me to do so, although I think that is pushing the boat, to be fair.
Scottish bankruptcy is different anyway.
So we've got the unconditional, unqualified proof with no mention of an alternative claim in England against the alleged undisclosed principal. In my respectful submission, that is an unequivocal election to treat shipping as their debtors in classic terms. But then on the facts, they went still further because they kept the New Zealand proceedings alive. It's not quite clear how they managed to do that, to be fair, because one would have thought they'd be stay, but they kept them alive. I think the reason is there's some evidence of this, that there was a suggestion by my own friends' clients that they could keep them alive because shipping had been in contempt of court. I think we do see that from Supplemental Bundle 2. I think there was a ruling by one of the judges in sorry, Brewing. Oh yes, it's tab 43. So it's tab 43 of bundle 2. This is quite early on. It's page 287. It's a judgment or a minute of a judgment of Mr. Justice Brewer, and it's actually after the voluntary administration. But he says in paragraph 3, it seems to me that where an application be made alleging a contempt of court by a company and by its directors, then there is a real possibility the court will permit the contempt proceedings to continue, notwithstanding the company going into voluntary administration. But that's all we know. Of course, we don't necessarily have full visibility on what was going on, but we know that the proceedings continued in New Zealand, and we know they were still extant in the period after the liquidation that occurred in 2023. And we know that because there was an exchange of correspondence in advance of various CMC hearings that were going to be taking place during the course of 2023. And the best place, if I may say so, to see the way the correspondence took place is actually behind one tab, and that tab is tab 57. And to read it backwards, if I can ask you to do that, it's not a very convenient way. It's just that's the way the email chain operates. So starting at page 36. Well, actually, probably the best place to start is 364. So we have an email to the registrar from Lowndes Jordan, and they are the law firm acting for my own friends' clients in New Zealand. They say we act for the applicant, attached jointly with the Respondents memorandum of counsel seeking adjournment of the case management conference. We haven't seen the memorandum, unfortunately, but we see that took place. So that was in March. It's going to be adjourned, and then you get to August 363. Good afternoon, Stephanie. Do you have any instructions of what Berge wants to do in respect of this proceeding? Let me know. I can take instructions for liquidators. Then Carl, who's the partner at Lowndes Jordan, replies, thanks for your email. Sort instructions revert as soon as they are to hand. At the top of the page, thanks. Court expecting a memorandum. Would you be able to email the court to advise that a memorandum or memoranda will follow as soon as possible? And then you get at 362 on the 10th of August the key request. Thank you for your email. We'll let the court know. As soon as you're able, please could you provide us with confirmation as to whether or not Berge claim in the liquidation is accepted by the liquidators. If the claim is accepted in full, then the current proceedings can be brought to an end. If the answer to one is no, please let us know whether the liquidators will consent to the action, to Berge continuing with its current proceedings, that's in New Zealand, against shipping, or whether an application for leave will be required, and so on. Please confirm whether or not propose to take any further action against directors or parties like me, I suppose, That was the third question. And that was on the 10th of August. And then basically there's a number of chases after that. We can see the correspondence as it goes through 361. Hi, Janko. See, we're doing another conference with the court on the 7th of November. Please can you update me on the current position of the liquidators in relation to the matters raised in our below earlier email. And that's why I wanted to show you it in the sequence it comes, because that below earlier email is clearly a reference back to the request on the 10th of August that we see at page 362. So working back up the page 361, hi Janko, just wondering whether you've managed to make any progress on this one. And then again on the 6th of November, further to the discussion with Carl this morning, please find attached a short memorandum in anticipation of the court conference, the conference tomorrow. That's a reference to the court conference. Please note this is subject to clients' instructions. They're based in Singapore. We know that clients are concerned about the continuing delays, seek answers to the questions set out in our earlier emails. And again, that's a reference we would submit to the 10th of August request. Then there are...
do you need all this? Isn't the point?
I don't, sorry.
The liquidators admit claim at the top of page 357.
My lord, yes, quite. Right. But there's more to it than that. It's not just a plain admission. I mean, clearly it is that. What we have is a request in August saying, we've got these case management hearings going on, we've got a set of proceedings going on. If the liquidator is prepared to admit our claim in full, we'll agree to discontinue the proceeding.
Well, there's no need for the money. That's obvious, isn't it? Really?
Quite.
These are just two different procedural routes to get your money.
Right. But what we get in so we get that full admission in the correspondence, but then we get another document which embodies the agreement, which gives rise to the discontinuance. And that's the document we see at 367 to 368, dated the 7th of December. Obviously, they got up very early that morning because the next event date was the case management conference on the 7th of December, starting at 9:30. And obviously, they're keen not to have to go to that hearing. They're instructed at that stage, not just by Alones Jordan, but Berge had Jason Goodall KC also acting for them. And over the page, you'll see notice of discontinuance to the registrar. This document notifies you that the liquidators have admitted the applicant's claim in the liquidation of the company in full. Accordingly, by agreement, these proceedings are discontinued. So, for all intents and purposes, my respectful submission, that amounts to a settlement. It's an agreement by the liquidator on behalf of the company to accept the liability of the claim in full. It's a settlement, and it has the immediate consequence of requiring my clients, and this is on the hypothesis we are an undisclosed principal, automatically to indemnify the company in liquidation. And that, we would respectfully submit, is the clearest possible evidence of a scenario whereby the rule in Kendall and Hamilton laws, I would suggest it's properly called Priestley, applies. Because you can't have my clients being liable both to the third party and to indemnify its agent. And I've done, so if you have any questions, I've given my own friend more than the time and I.
There might be a question from behind.
Of course. Yes, I'm sorry, my lord. The footnote.
Oh, yes.
Footnote 5 in this diocese, a judgment in Taylor. The case she refers to, or presumably, it's a slightly strange answer. The footnote doesn't actually mention the case, even though she says the Court of Appeal Authority. It says, although it's not an objection that the principal might in theory have the right of reimbursement against the agent to recovery any payment already paid, this would not be an adequate remedy if the agent was impecunious, and the likelihood is that the third party would only be looking to the principal, isn't it? In that situation, it's not the same.
Yeah, it does, but then it's clear that in that paragraph she's referring to
And I'm told it's clear. I think the easiest thing, my lord, if this, without, and I know we post-hearing additions are to be avoided if at all possible, but we might be able to provide your lordship with footnote 5.
Well, don't worry, we can find.
Because I'm finding this, I don't want to mislead your lordship. That's
No, that's absolutely fine.
All I would say is it appears the
Beyond
footnote
that.
doesn't actually mention a case.
Yes.
As I said, perhaps my best answer
Well, she
would be
obviously
that,
thinks it's such
that
a
Scarf
well-known
and
case
Dean
that
has
we
the
ought
point
to know.
at the highest Lord's level. You don't know, I think the case they're thinking might be Arcton and Brooker, which is a court appeal case.
All right.
But, my lord, unless there are any other questions, those are my submissions.
No, thank you very much indeed. Yes, Mr. Hay.
My lady, my lords, first of all, thank you to Mr. Bailey for cutting his cloth. Secondly, I think I've identified the source of that quote, and I'll be taking you to the case so we can look at it. Before I start, I'm conscious that there is a lot to get through, so if it's convenient to the court, I would start with election and then move to the merits test afterwards, even though it's illogical, but it might make more sense.
Well, up to you how you structure your submissions.
All right, well, on election, I intend to make 3 headline points. First, election and merger are different. In particular, merger, we say, is the inevitable effect in law of obtaining a judgment, and that is what explains Kendall and Hamilton. Election is a question of fact that needs to be answered in all the circumstances in a given case. My second headline point is that in this case, there is no judgment, and there is also nothing equivalent to a judgment. In other words, nothing that would also have the inevitable legal effect of discharging the exporter's liability. And third, my clients have also not done anything that, on the facts, amounted to what Mr. Bailey called a vanilla election. Turning then to my first point, election and merger are different. Election ordinarily relates to the choice between inconsistent rights. So the obvious examples are, do I accept the reputed breach or affirm the contract? Do I accept or reject non-contractual performance? Or, as in the Kanchenjunga, does a ship owner follow or reject an order by a charterer that the charterer was not entitled to give? And the idea in all of these cases is that one has a choice, and exercising the choice is liable to change the legal landscape. And for this purpose, can I take you to one of the textbooks, which is a tab 57, and in the PDF starts at page 1489. It's volume 3 of the authorities book. And this is the Estoppel by Conduct in Election textbook by Patrick Keane, and the relevant quote is at page 1500. And it's a second red line. Alternative and inconsistent rights typically exist when a transaction is voidable or events occur which give rise to a right, strictly a power, in one party to terminate a valid transaction or reject a non-contractual tender of performance. And then over the page at 1501, which is paragraph 14003, he says the characterization of a right of election between inconsistent rights as a power brings out its real nature and distinguishes it from the rights extinguished or terminated by its exercise and the new rights that are then created. It identifies the essential basis of all elections between inconsistent rights and the nature of an elector's decision. We agree with that analysis, my lady, my lords. And for that reason, one must be very careful when trying to read across propositions from different areas into the present context where the principles are different. So where a contract has been either affirmed or been terminated, it either remains extant or has come to an end. It cannot be both, and that is why there's an inconsistency. But there's no inconsistency, as my Lord Justice Zacaroli said, between suing the agent and the principal. On the contrary, the effects of merger demonstrate that the law proceeds on the admittedly strange basis that they are both liable on a single cause of action. And the easiest place to look at that is actually my learned friend's skeleton, which is tab 11 of the core bundle, page 110, where at 66.3 it is said, the principle underlying the rule in Kendall and Hamilton is that there is only a single liability, and citing for this proposition the judgment of Julia Dyers QC as she then was. Now, if we look at that judgment, that's in tab 40 of the authorities bundle, which in hard copy is volume 3. The page that I'd like to start off with is page 778.
Volume 2.
It's volume 2, in fact, not 3. My apologies. So page 778, where she sets out at paragraph 3 what this case is about, and she says 4 lines from the bottom of paragraph 3, this raises an interesting and difficult question concerning the extent to which a default judgment obtained against an agent bars a subsequent claim against an undisclosed principle, the so-called rule in Kendall and Hamilton. And then when she discusses Kendall and Hamilton, at page 780 of the bundle, she rightly says that at paragraph 201, which is in the middle of the page between the 2 hole punches, the other members of the House of Lords treated the case as one of joint contractors and decided it solely on the basis of King's case. And that's a reference to King and Hoare, which is a merger decision. And that rule, that an action or a judgment against a joint debtor releases the other, has been abrogated by statute by the 1978 Act. So that rule no longer exists. Nevertheless, the judge went on to hold that she believes that a similar rule does exist in the agency context, and the justification for it, she says, at paragraph 226, which is on page 787, by the G, she says that the better analysis is that the rule preventing a claimant from suing an undisclosed principal after obtaining judgment against the agent is one of merger. And that is why, at paragraph 244, which is 790 of the bundle, she said that if the claimant wanted to preserve his options, you either set aside the judgment, because that gets rid of the merger problem, and then you pursue all the defendants in one set of proceedings. So, certainly the judge in Taylor thought the correct analysis was merger on the basis that there is only a single liability, and that liability is discharged. But whilst that is the effect of merger, not all judgments give rise to merger. So, first of all, the Supreme Court in Nasir and Zavaka, which is at tab 51, has held that a declaratory judgment does not give rise to merger. But presumably, that would be caught by Mr. Bailey's rule, because a declaratory judgment pronouncing upon a liability would presumably also give rise to an indemnity. And secondly, foreign judgments.
Not if the defendant hasn't been ordered to pay anything.
Right.
Well, I'll get back to the settlement idea, but the short point is, not only is there no case that has ever suggested that a settlement agreement would have the same effect as merger in judgment, there's no textbook that has ever analysed this case as one of exposing the agent, the principal, to an indemnity claim. And thirdly, the real point would have to be that it becomes no longer a contingent liability, but somehow a crystallized one. And it's difficult to see why that would make a difference. Because at any stage where the agent is liable to be sued, there must, if the agent was in fact acting within the scope of their authority, the agent would have a contingent claim against the principal. In other words, insofar as the agent is liable, the agent would say, well, so is the principal. Or putting it differently, the agent would at any stage of those proceedings be able to add the principal to the proceedings. And therefore, if it is right that a contingent liability doesn't have this effect, it's difficult to see why a crystallized one would. Certainly the cases, and I'll also take you to Clarkson, Booker, and Angel, discuss this as a merger case. So as I say, declaratory judgments don't give rise to mergers, and secondly, foreign judgments also don't give rise to mergers. I don't think that's controversial, but the authority for that is the Indian Grace. It's at tab 1 of the Supplemental Authorities bundle, and at pages 15 and 16, Lord Gough says that that effect has not been overridden by section 34 of the Civil Jurisdiction Judgments Act. In other words, there's no statutory merger, even though there's a bar on subsequent proceedings. So therefore, in circumstances where Mr. Bailey accepts there is no judgment,
Would a foreign judgment have the effect of terminating the right to proceed against the principal?
we would say no,
Because
there's no merger. And it's merger or bust in our submission, or in law. So insofar as it is said that in law, a step discharges the principal, we have to accept, subject to the Supreme Court holding otherwise, the effect of merger in judgment is that one can't sue the principal even though the claim has not been satisfied. Despite all the misgivings in all the textbooks, that's the law, at least in this court. But subject to that highly technical and on any view unattractive rule that presupposes that there is a single liability, because unless there's a single liability, merger wouldn't have this effect. It presupposes a single liability against two defendants, which at least on one view isn't the correct analysis. But in those circumstances, we would say no, a foreign judgment doesn't have that effect. Of course, a foreign judgment might amount to a vanilla sort of election, but it wouldn't have the same effect as an English judgment. So then the question is there anything equivalent to a judgment in this case, by which we mean something that in law has the same effect? And if not, is there something short of a judgment that the exporters can rely on, which on the facts amounts to an election? Now, in their skeleton, which is tab 11 of the core bundle, page 111, paragraph 66.4, it was said that pursuing an agent via bankruptcy procedures is equivalent to the entry of a judgment. That is, I think, the submission that Mr. Bailey disclaimed as going too far. We agree that cannot be right, because as a matter of English law, a proof of debt process does not have the same effect as a judgment. The authorities dealing with this are in the supplemental bundle. Maybe that is what prompted the rethink. It's White, which is a decision of Lord Hoffman, and that is then discussed in the Lehman Brothers litigation, where obiter, the Supreme Court, splits 3-2 on whether that's right. But putting all of those technical points to one side, we say that the correct analysis is that making a claim in a bankruptcy is no different from making a claim in an ordinary court process. And insofar as my learned friends nevertheless rely on David Logan and Schultz, we say that reliance is also misplaced, because if one looks at tab 9 of the authorities bundle, which in the hard copy is at volume 1, in the PDF, the relevant page is at 153, there are 3 propositions that his lordship articulates. The first proposition is just at the very top of the red line on the left-hand side, where he says he, so the claimant, undoubtedly cannot proceed against both parties. Well, that's wrong. And Mr. Bailey accepts that's wrong. On any view of the law, the claimant can proceed against both parties at the same time. Then the second proposition.
If he does, he doesn't get judgment against both parties, does he?
No, at the end of the day, they'll have to decide who he wants a judgment against.
So how does that work? The judge gives judgment saying whether there is an undisclosed principle or not, and
then you elect.
Claimant then makes an election who will tend to
Which
judge
is one of the many
against.
reasons why this is a hugely unattractive doctrine.
Well, look, can I just interrupt there just to say there is authority, there's so much out there, but there's one particular case dealing with that very question about what the process is, and what the judge said is, I'm not going to hand down my judgment. You're going to have to elect, and then I'll hand down my judgment. If you'd like to see it, we can...
I think it's mentioned in the skeleton. I think it's one of the husband and wife authorities, isn't it?
It's a recent case.
There's really old authorities, for example, where what happened is that husband and wife get sued. Husband appeals the judgment, then it's remitted, and then the husband says, well, you've got a judgment against my wife, that's it. Obviously, most of these cases have now been abrogated by statute because of 1978 Act. So all the very unattractive consequences of this, which followed from the law of joint debtors and merger, are now of historical interest only. But yes, that is how it would work, because of merger and judgment applying to undisclosed principle.
Right.
So the second proposition is the one that Mr. Bailey took you to, and it was the one about whether it's conclusive on the question of election, and I'm not going to say anything more on that. Insofar as it describes the effect, that might be right, but we say the process is through merger. And then the third proposition, but I think that's now been abandoned, is that so the second is in the second column, the right-hand column, and there it is said that the proof of debt process is the same as a judgment, so we just say that's wrong.
Have I got this right? Tell me if this is how things work. Mr. Bailey is running two alternative routes under this respondent's notice. The first is the rule in Kendall and Hamilton, or Priestley and Fernie, where he says if you get a judgment, then that extinguishes the right to proceed against the principal, regardless of whether you know the facts, because it's a single claim or a single right. You can't have it against both. Once you've got a judgment, there is then a liability to indemnify, which crystallises it, and that is that, and that a settlement is equivalent to a judgment, because that also crystallises the right and gives rise to a right of indemnity. You say in response that that is not the case because the rule is founded on merger, and a settlement doesn't give rise to a merger in the same way that a judgment does. There's then a second line of attack, which you're dealing with, which is what Mr. Bailey calls a classic or vanilla election, where you have to have knowledge of the right, and for present purposes he accepts knowledge of the legal consequences of the right, and you're looking to see whether there is a sufficiently unequivocal act, and you say there isn't, because none of what we've seen is sufficiently unequivocal to give up the right against the principal. But so keeping those two, is that a summary of what you understand you're dealing with and your responses to it?
Yes.
Or is there more to it?
There's probably more to it, but that is certainly a more than adequate summary, my lord.
Yeah. Okay. All right. Well, I understand where we're going.
There is one Court of Appeal authority I do want to show you, my lady, my lord, which is Clarkson, Booker and Angel, and that's tab 13, page 191.
Sorry, which page?
191 is where it starts. And there are two judgments, one by Lord Justice Wilmer, another by Lord Justice Russell. If we start at page 201, we can see that this was a claim that related to a travel agent who booked some flights for 12 people from Athens to London. And the defendant said that in booking the flights, he was acting as an agent for Peters and Milner, and the appeal proceeded on the basis of a concession that one can see at the top of page 202. Counsel for the plaintiffs thereupon conceded on instructions that the defendant, in booking the flights, did in fact act as agent for undisclosed principals, namely Peter and Milner. And the chronology in that case was that in July 1962, the claimant wrote to both Peter and Milner and the defendant. You can see that by the first hole punch. So at that point, the claimant already knew that those flights had been booked on behalf of somebody else. There was no suggestion that the letter seeking to be paid by both was an election. That is by the second hole punch. It is abundantly clear that up to this point, the plaintiffs had certainly made no election. Then in September, the plaintiff issues a writ against the principal. Then in November, that's at the bottom of the page, the principal's lawyers write to the plaintiff informing the plaintiff that the principal is insolvent, which is 5 lines from the bottom. And then in December, the plaintiff issues the writ against the agent, which is the defendant. And the question was whether the issuance of proceedings against the principal constituted an election that prevented the plaintiff from pursuing the defendant agent. And at page 204, Lord Justice Wilmer records that most of the cases cited related to parties being sued to judgment. He refers, amongst others, to Priestley and Fernie and Kendall and Hamilton. And over the page, on page 205, he refers to a dictum by Lord Justice Atkin, which he says is of no little relevance. And there, Lord Justice Atkin distinguishes the case of suing the principal to judgment, which he says depends not on election but on the construction of the contract. But it has the contract the plaintiff is prevented owing to something he has done from recovering judgment against the husband. And then election is a separate principle, which at a stage short of judgment may bar the remedy which a person could otherwise have. And this case is authority for the proposition that in the absence of merger, the question of election is one of fact. And one can see that at the bottom of 206. And he refers to Scarf and Jardine. And he says, I don't understand him to mean that where proceedings have once been commenced against one or two possible debtors, a plaintiff is necessarily precluded as a matter of law from subsequently taking proceedings against the other. And Scarf and Jardine was the case, my lady, my lords, where either the two partners were A and B, or B and C. But it could never have been A, B, and C. And in that case, it was held that having proceeded against A and B, one couldn't then proceed against B and C. And the counsel here, in this case, had conceded there must be some cases where the mere issue of a writ could not be held to amount to binding election, for instance, where it is issued for the purpose of preventing limitation from running out. And it is in this case, my lady, my lords, where it is said that whilst institutional proceedings can be prima facie evidence, one has to look at all of the circumstances. It must be shown there was a truly unequivocal act. And at page, that's at page 208, at the very bottom of page 208. It must be shown the decision to issue proceedings was a truly unequivocal act. And over the page, between the two hole punches, there is not and could not be any suggestion that the defendant was in any way prejudiced by the course which the plaintiffs took, or that he was in any sense lulled into a false sense of security. And then the conclusion is at the bottom of the page. On the whole, though I regard this as being near the borderline, unable to disagree with the conclusion of the judge that there was no election. So drawing these threads together, And Mr. Berry rightly points out that on page 209, by the second hole punch, one can see that Lord Justice Wilmer expressly says that had the plaintiffs carried out their threat to obtain judgments against Peter and Milner, they would of course have been precluded from subsequently taking proceedings against the defendant, for their cause of action would have been merged and the judgment obtained. So this is further authority for the proposition that the Dyers QC articulated, which is that the relevant proposition, the relevant principle is merger, and therefore also authority for my submission, which is that it's merger or bust, at least in law. So there are three critical propositions that emerge from the Lord Justice Wilmer's judgment, we say. One, election and merger are different. Two, election requires an unequivocal act with full knowledge of the facts, and potentially it might require reliance, or at the very least, it ought to be some representation that is actually being made to the person who it is said is being discharged. And an act taken in the face of a time bar is unlikely to be unequivocal. That's the third proposition. Or removing the double negative, an act taken in the face of a time bar is likely to be equivocal, and so will not, on the facts, constitute an election. And if one now turns to Lord Justice Russell's judgment, at page 211, I'm not going to read out the entire quote, but the same three propositions emerge. So he says, the judgment supersedes the contractual right against either, and if obtained against the agent precludes action against the principal, even if the principal was ignorant of its existence and therefore unable to elect. That's by the second hole punch. That's authority for the proposition that this is about merger. As to the test, he says in between the first and second hole punch that the external acts of the plaintiff must lead to the conclusion as a matter of fact that the plaintiff has settled to a choice involving abandonment of his option to enforce the right. And that might be what my Lord Justice Zacaroli was referring to, which is that by making a claim against the agent in the insolvency, one is saying nothing about whether one is abandoning a right that is being asserted in parallel proceedings. I would say that's the right analysis. And then over the page, it just starts at the very bottom of page 211. He says that the writ is basically a statement that the plaintiff makes a claim against the defendant. As I have said, it doesn't necessarily involve abandonment of a similar alternative claim against another defendant. That's now at the top of page 212. It would not do so if there was simultaneous writ against the other, nor would it do so if the plaintiff was simultaneously expressly informing the other that the alternative claim was not abandoned, nor would it do so if simultaneously the plaintiff was maintaining vis-à-vis the other, the attitude that he might be looked to for liability on the contract. And we say, well, there can be no clearer representation to the exporters that my clients will be looking towards them than having issued a claim in England and pursuing that claim. Now, looking at the facts that...
I suppose you would say that if pursuing a claim is an election, then you might as well have elected to sue the principal by pursuing the claim in England as the agent by putting in a proof.
Yes. Yeah, well, say that the only problem with that submission is that we've joined them to a claim against the agent.
Yeah.
So, fundamentally, all I have to establish is equivocal, and certainly suing them both at the same time, whether in the same forum, whether under the same claim form, or whether by the same means, i.e. in court versus in liquidation, is all equivocal.
Well, Mr. Bailey really put his emphasis partly on the making of the claim, the submission of the proof, but partly on the acceptance of liability.
Yes, well, I'm going to just have a look now at how it's put in the skeleton argument, address what I think are the different factual points that are being relied on. It's from paragraph 73 of his skeleton, which is page 115 behind tab 11 of the core bundle. And there it is first said, the exporters do not need to rely on steps that owners took prior to Berge learning of the exporter's involvement. Now, I think the better analysis would be to say that they cannot rely on those steps. It's not that they do not, they can't. At 74, they then set out what they say are the relevant facts that they do rely on. And the first one is submitting the claim in liquidation, which is 74.1. And whilst I'll return to the question of knowledge in a moment, taking the exporter's case at its highest, it is that owners had adequate knowledge by the 25th of May 2023. However, we say that for at least two reasons that submission was not unequivocal. First, because they were pursuing a claim against the exporters, and secondly, because the step was taken under pressure of a time bar. That's an important point, my lady, my lords, because as the Court of Appeal recognised in Clarkson, a step that might otherwise be unequivocal is not so when it is taken in the face of limitation. And in the supplemental bundle, which I think in hard copy is going to be volume 2, on the screen is page 332 of the supplemental bundle, tab 48. I've got a rogue reference. It's 322, not 3. I think I might have said something else. It's page 322. It's a notice to creditors to prove debts or claims. It's dated the 26th of April 2023, and it fixes the 26th of May as the date on or before which the creditors are to make their claims. Creditors not having made a claim by this date may be excluded from any distribution made. And in our submission, if making a claim in court to beat a time bar is equivocal, then so is making a claim in a liquidation that would otherwise be time barred. There's no principled reason why one should be equivocal and the other one should be unequivocal. And it would also have absurd commercial consequences, because basically what it would require is that the claimant would have to bet the house at that stage on being able to prove a claim against the principal, which is being denied at that stage, or make a claim against the agent, but then forever hold his peace. And that can't be right. Returning then to the second fact that they rely on, it is the admission that Mr. Bailey took you to. And on that we again say that an admission of liability by the agent and a subsequent discontinuance, just taking those two things in stages. A discontinuance against the agent is difficult to be seen as being unequivocal, as an abandonment of all claims other than the claim that is being discontinued. If anything, one might think that discontinuance amounts to an abandonment of the claim being discontinued, but here it is being relied on to say that it's an unequivocal action in suing only the person against whom the claim is being discontinued, which isn't necessarily the way one would expect that argument to work. But in any event, the admission of liability by the liquidator on behalf of the agent cannot, in our submission, constitute an election by the third party to sue only the agent. If Mr. Bailey is right, the agent, by admitting liability, can choose to discharge the principal vis-à-vis the third party. There's no principled rationale for such a rule. it also makes no sense because the whole idea of election is that it is the third party making the choice. But if Mr. Bailey's rule is correct, the choice is being taken out of the third party's hands and is given to the agent. And the moment the agent writes a letter that says, I accept I'm guilty, that's it. And we say that can't possibly be the correct legal analysis. And of course, this is no more than an admission by the agent, because an admission by the liquidator, who at that time is effectively the agent. And then turning to the question of full knowledge of the facts, there isn't any case, and Julia Dyer's QC dealing with the alternative way of putting it in Taylor hasn't identified a case where there was an election in view of the full knowledge of facts, so a vanilla election, where the principal was denying that the agent had acted on its behalf. Mr. Bailey will correct me if I'm wrong, but there doesn't seem to be a case where, whilst the principal is denying that the agent was acting on their behalf, nevertheless, the third party was held to have elected. And unless I can assist further on election, I was now going to turn to the merits test, which is, does any of this actually matter?
I just asked this, would you accept that if you were to accept a dividend in the liquidation of the agent, that would be an election? And I say accept a dividend, not just one being declared, but accepting it.
Luckily, I don't have to answer that question because it hasn't happened. Strictly speaking, if you were the Supreme Court asking me the question, I would say no. Because in the Supreme Court, our argument would be that only satisfaction is good enough.
In full? In
full. So therefore, to the extent, of course, you're partially satisfied, well, you can't recover it twice. But there are problems with that, at least in this court. That's the intellectually honest answer. And of course, subject to... in law, it would certainly not have that effect. I think even in this court, we can argue that.
I'm asking about election.
But in fact, I can see that it might be unequivocal in certain circumstances. But in law, because it's neither merger nor satisfaction, we would say that in law, it doesn't have the effect of extinguishing the principal's liability, even if you are paid a partial dividend.
It's not the priestly principle.
It's not.
But I'm asking about
the unequivocal. Then that would depend on all the circumstances of the case. And yes, there might be a case where accepting a dividend would constitute election, the same way as just issuing a claim might, in certain cases, constitute an election. If it's sufficiently unequivocal, it's an abandonment. So in this case, we would say, well, we're not abandoning any rights against the exporters, even if we accepted a dividend. So that's why it can't be a vanilla election. But yes, there might be circumstances where it would be an abandonment, and therefore, in fact, would be an election. Not in this case, because we're still suing the principal. We're not suggesting we're abandoning any rights by doing so, but it can happen.
I suppose now, being forewarned, you will say something like, well, we accept it on account, but without prejudice to a long list of things.
Yes.
No warranty, Mr. Berry, that will work.
No.
However, it's on the transcript.
Now, on the merits test, I'll try to take this quite quickly. And it might be useful for me to first set out what is not in dispute as to whether there is a merits test. First, it is not in dispute that a claim is liable to be either struck out following a strikeout application or dismissed following a summary judgment application. But where a court strikes out or dismisses a claim, the court is exercising its jurisdiction to decide the claim. It is not without more a reason to hold the court has no jurisdiction to do so, which is what this appeal is about. And in answer to my Lord Mills's question, Mr. Goodkamp said, well, there's a policy not to vex the foreign litigant. That's right under the gateways. It is obviously correct where if the English court is asserting jurisdiction over a defendant who is outside of the jurisdiction, and that defendant has not consented to that, there are important policy reasons why one shouldn't vex the defendant with an otherwise hopeless case. But it would not be right to say that that applies under 6.33. And in fact, my learned friends concede that if this was an exclusive jurisdiction clause within the Hague Convention, there wouldn't be a merits test. So if this is the overarching policy in every case of service out, then that policy is not being achieved by the CPI as drafted. And of course, the reason why summary judgment or strikeout applications may constitute a submission to the court's jurisdiction is because when deciding the merits, ordinarily, the court is deciding the dispute in respect of which ex hypothesi it has jurisdiction. And below, the respondents didn't seek a strikeout, they challenged the court's jurisdiction. Secondly, it is also not in dispute that a claim in respect of which the court does have jurisdiction may be stayed. And this applies both to claims served within England and served outside of England. For this reason, the Canadian and New Zealand cases do not assist the exporters. Those are authority for the proposition that there's a forum non-convenience test, despite being able to serve as of right. But of course, that's unsurprising, because post-Brexit, even a claim against a defendant domiciled in this jurisdiction is liable to be stayed on forum non-convenience grounds, even though under the EU regulation that wasn't possible.
I thought the Privy Council case, in the Privy Council case, the result was that the court said there was no jurisdiction because the merits were not strong enough.
So I'll take, if I can, can I go through my other points first? And if I have time, I'll come back to that case, because I'm not trying to fob my lordship off. It's more that on my analysis, those cases are simply not relevant because one has to start off with the text of the CPR and the purpose of those reforms, and cases from 50 years ago don't actually shed much light on that. So the real disagreement between the parties is whether, as we say, the party seeking a stay must identify strong reasons before a court can stay a claim in respect of which there is English jurisdiction clause. Some cases described as overwhelming reasons, and those, of course, we say go beyond the forum non-convenience factors, and merits are not a strong reason. So if one is in the Donoghue and Aramco arena, a strong reason is necessary, and merits have never been held to be a strong reason within the meaning of that test. And this is a purely technical point, but if one looks at the order below, which is tab 13, page 138, the court below held that the English court has no jurisdiction. It did not hold that it shouldn't exercise its jurisdiction, which is a separate thing altogether under CPR 11, where one can either dispute the court's jurisdiction or argue that the court shouldn't exercise it. And the reason I said it's a purely technical point is because the Singh and Das argument isn't taken against us, and the answer to that would have been, well, this is actually you seeking to vary the order below, and Singh and Das provides no limits on what a cross-respondent can say in response to cross-appellant. As to the proper construction of 6.33, the CPR being a piece of secondary legislation, the task of the court is to seek the meaning of the words used, read in light of the legislation as a whole, and in light of their context and purpose. So therefore I have three submissions: text and context, purpose, and precedent. If one looks at the text of Rule 6.33(2)b, which is in the White Book at page 288, does the court have White Books?
Nope, not in court anyway.
Okay, that's fine. I've printed off some copies. I have enough, I think, for everyone. I thought I had spotted White Books in the back, but that was perhaps me. That was my view knowledge.
It'll be out of date.
All right, well,
Yes.
okay. Yeah, that's okay.
Thank you very much. Yes.
So 6.33(2)b is at page 288 of the White Book. And one can see under 2b that the claimant may serve the claim form A, where it's an exclusive jurisdiction clause within the meaning of the Hague Convention, B, the contract contains a term to the effect the court shall have jurisdiction, and C, the claim is in respect of a contract falling within B. So the short submission, my lord, my lady, my lords, is that the provision itself contains no merits test. And what is more, as we understand the respondent's case, they accept that there's no merits test under A, but they say that there is one under B or C, and it's difficult to see how one reconciles that with the language of the clause, which draws no such distinction. There are three provisions that we say are relevant context, and those are 6.34, and 6.34 is at page 295, where it is said that the claimant intends to serve a claim form on a defendant under Rule 6.33. The claimant must file with the claim a notice containing a statement of the grounds on which the claimant is entitled to serve the claim form. No suggestion that they need to certify anything about the merits. In stark contrast to that, at 6.37, which is page 298, where an application for permission is made under Rule 6.36, which is the gateways, one must set out that the claimant believes that the claim has a reasonable prospect of success. And in my submission, in circumstances where Rules 6.33 and 6.34 make no mention of the merits test, whereas the rules at 6.36 and 6.37 do contain such an express reference, because of expressio unius est exclusio alterius, the draft who chose to expressly include a merits test in one provision, but chose not to include it in another provision, intends for the former, but not the latter, to contain such a test. Next, my learned friends rely on the minutes, which are at tab 54 of page 1443 of the bundle. And on this, my submission is that the draft has deliberately used the wider definition of a court of an exclusive jurisdiction clause that was used in the gateway, instead of using the Article 25 definition. But the effect was, or the intended effect was, to replicate Article 25. And of course, under Article 25, there was no merits test. So the position was that prior to the reform, the vast majority of exclusive jurisdiction clause cases would have been dealt with under Article 25 of the regulation. But the draft has intended a wider definition of exclusive jurisdiction clauses and put it into the same provision. My learned friends rely on the statement that it would remain possible for defendants to challenge a jurisdiction at a later stage. This merely states the obvious, namely that a defendant can challenge jurisdiction on the basis that the test wasn't met. For example, the claim might not fall within the ambit of Rule 6.33. Or indeed, it might be for a different reason. So forum non-convenience would always apply in the same way as it would apply against a defendant who was served within the jurisdiction. What this does not say is what the grounds are on which one can challenge such jurisdiction. And this brings me to the last case, which is Donahue and Armco, which is at tab 28, which is at the very end of volume 1 of the authorities bundle, page 507. And one can see from the headnote, which is at page 507, that proceedings were issued in New York that were at least in part in breaches of exclusive jurisdiction clauses. And the only paragraph on which we rely, or the principal paragraph on which we rely of Lord Bingham's judgment, is at page 517, which is paragraph 24, which is to say that if contracting parties agree to give a particular court exclusive jurisdiction to rule on claims between those parties, the court will ordinarily exercise discretion, whether by granting a stay or by restraining the prosecution of proceedings in a non-contractual forum, to secure compliance with the contractual bargain. And we say that is the relevant principle in this case. And Dicey summarizes the position at paragraph 12106, which is tab 55, page 1472. And there the editors of Dicey say that the approach of the court to jurisdiction agreements does not in principle draw significant distinctions according to whether they relate to an English court or a foreign court. In each case, a strong case will be required to justify the grant of relief, which has the effect of allowing a party to a contract to resile from its terms. And that's what this is really about. If the exporters are party to a jurisdiction agreement with my clients, they are seeking to resile ex hypothesi from a contractual bargain that they have made. And there's no lacuna in the law if this court refuses to decline jurisdiction on the grounds of a merits test. On the contrary, there would be a lacuna in circumstances where if this court declines jurisdiction, no other court will have jurisdiction. Because all other jurisdictions will say, well, you can't sue the exporters in New Zealand because you've agreed to sue them only in England.
But if we decide that your clients do not have a seriously arguable case sufficient to get over the low hurdle of the merits test because you have elected, what's the point of accepting jurisdiction when the next move will be that they strike you out and succeed?
Well, you might ask that of Mr. Bailey as well, in the sense that...
asking you.
In the sense... Well, the point is this. There will then be a judgment on the merits. So the contractual forum will then have made a determination on the merits of the case. And that is going to have different effects from what is an entirely interlocutory decision, which isn't on the merits. So in law, there's a different effect.
Well, you'll be better off, because there won't be a res judicator decision against you, which there would be if they struck you out under reverse summary judgment.
And that's a reason to congratulate my clients for taking this intellectually honest position. But more seriously than that, there is a fundamental difference between a case where the parties have entered into a contractual bargain and there is an exclusive jurisdiction clause, and the courts all the way up to the House of Lords have recognised that fact, and there's a plethora of factors that are relevant to whether a stay should be granted in such a case, and where there's a risk of, for example, injustice in the contractual forum, or there's going to be a multiplicity of proceedings that could lead to inconsistent judgments. There's all sorts of reasons that do constitute strong reasons. Merits are just not one of them. And that's perhaps as far as I can take it on the Donoghue case. I've seriously overstayed my welcome. But I wonder whether I should take you to the Q8 decision, which is the New Zealand Privy Council decision.
Well, are you saying it didn't decide jurisdiction on the merits?
No, I accept that is what the effect of the case was, but
You accept that the decision in the case was that the Claimant did not have a sufficiently strong case on the merits,
Yes.
and that jurisdiction was declined.
Yes,
for
but
that
it
reason.
wasn't an exclusive jurisdiction clause case.
No.
It wasn't that. So therefore, it didn't have to in any way reconcile itself with Tiaki and AMCO, and also, unlike us, there was also a different practice in terms of how the rules were phrased. If one looks at page 416 of the authorities bundle, there wasn't this distinction, or it is unclear whether there was, this distinction between the way 6.34 is drafted, which requires a statement of the grounds, and 6.37, which requires a certification of the merits. And if one then looks at page 416 of the report, of the bundle rather, not the report, the bundle, one can see that the fact that it is said at the very, basically by the second whole point between E and F, the fact that unlike Order 11, which was then the English order, Rule 219 does not require supporting affidavit, is partly offset by the need that rule for a statement of claim and not merely a writ. And the absence from Rule 131 of a power to direct trial or preliminary issue contrasts much more in theory than in practice with the English procedure. And therefore, the Lordship said, those are not strong indications. And so therefore, it's in practice not very different from Rule 6.37, where they have to address the merits, because they have to address the merits of the claim in their statement of claim, which under the English rule, one has to do in a 6.36 and 6.37 case, and one doesn't have to do in the 6.33 and 6.34 case. So not only is it an unhelpful guide to the interpretation of the intention of the Rules Committee in 2020, it's in any event distinguishable. One, not an exclusive jurisdiction clause case, and in any event, to the extent inconsistent with Donoghue and AMCO, this court needs to give effect to Donoghue and AMCO. And two, the rules are differently worded and are much more like the gateway rules.
Yes.
Thank you.
Thank you very much.
My Lord, if I could briefly deal with a few points, the time I have available. There's one point I'm going to ask Mr. Goudcamp to deal with, which is the 634 point, if I may. So I'll save a bit of time for that. But can I just make a few points in reply? The first is, what's the reference? The first is, my own friend essentially said, it's merger or bust. I think those were his words. And he referred to the fact that Miss Julia Dyer said she thought the better explanation of the rule in Kendall and Hamilton was merger. And it's fair to say, of course, he didn't take you to this, but it's fair to say that the Court of Appeal, when they looked at the point, said they would rather have had more time to think about it, the juridical basis of the rule. Thank you. Now, my point is this, that the difficulty in that case was an attempt effectively to pigeonhole the rule by giving it one title or another. In fact, if you see the way the argument was put before the Court of Appeal in Taylor and before Miss Dyers, one party was saying, oh, it's election. The other party saying it's merger. Now, what I've tried to do is to take the bonnet off the car and look inside, rather than describe its title. And what we say is, it's the effect of the judgment, rather than whatever label you give it, which gives rise to the reason for the principle being released. And it's true to say that merger may well be a sufficient explanation in many cases where the rule applies, but it's not an exhaustive explanation. And the reason for that is because, as we've seen from the three cases I took you to, Priestley itself, Lord Cairns, Lord Stormont's judgment, they all identify the reason why the principal is released is because of the obligation to indemnify. Now, it may well be, as I said, a judgment or the rule could often operate when there's a res judicata, could operate when there's a merger, but it also operates in those circumstances, in my respectful submission. So the merger or bust point falls away, and if I may say so, my own friend's reliance upon his point about a foreign judgment rather reveals the point. Because a foreign judgment would still trigger the obligation to indemnify, even if it didn't satisfy some rather even more arcane doctrine, perhaps, than some of the ones we've been looking at in this case, the way in which the doctrine of merger operates. So the merger or bust point, in my respectful submission, is not an answer. My friend relied upon the time bar point in the context of lodging the claim. I'm just put my point on the time bar very quickly. The time bar may determine the timing of the proof.
I mean, if you need to go on for a few minutes beyond 4:15, we will.
Well, that's very kind, my lord. I try to make sure I make the points that matter.
If you make the points that you need to make.
Well, can I give you the answer on time bar, which is that a time bar may determine the timing of the proof, but it doesn't determine its contents. The election in this case comes not from anything other than the fact that its contents are utterly unqualified, utterly unequivocal. They make a clear statement asserting the liability of shipping without any mention whatsoever of a possible alternative claim, even though they pleaded or sought to plead a claim against my clients several months earlier in England. In terms of settlement, my learned friend said the odd if an admission per se by the agent could operate as an election because you require conduct on the part of the third party to complete the process to trigger the obligation to indemnify. Now, I don't necessarily accept that's true, but even if he were right about that, that's why I rely upon the fact that a consensus was reached. It wasn't simply a unilateral admission that came out of the blue by the liquidator. We had correspondence we were taking you through, whereby the owner's solicitors pursued over several months a request for an admission, otherwise threatening to seek leave to continue the claim. And it was only on the basis of that admission being made that the parties thereupon agreed, as you saw from the minute of discontinuance, to discontinue the proceedings. This was not a unilateral admission by the agent. It was a consensual process and resulted in what, for all intents and purposes, is a compromise which triggered the obligation to indemnify. So that's why the rule applies. As far as the dividend is, it's a question the learned friend answered from my Lord Justice Zacaroli. In my submission, accepting the dividend, save for in exceptional circumstances that I can't conceive of, but I accept may possibly exist, we would submit, necessarily amount to an election. Now, as far as that's all I wanted to say on election. I just want on the merits test. There's there's one point on the rules I quite like my learned friend Mr. Gowdkamp to deal with. He's more familiar with the detail than I am, but can I deal with a few of the points my learned friend makes? The first point is he seeks to suggest that there is no real rationale for a merits test in the context of a gateway which provides for jurisdiction in the event that the parties have agreed to a jurisdiction clause in favour of the English courts. Now that's right. It would suggest that there should never have been the requirement that existed until 2021 to seek permission before one relied upon a jurisdiction agreement for service out. This is the common law position I'm talking about, not the convention position. We all know that the Brussels regulation brought in a straitjacket approach to jurisdiction which deprived the English court of its discretion. Some may say we're into the Brexit dividend now. We've got we've got our discretion back. It's a political point, but I am saying it is a consequence of Brexit that the discretion we had, we now, if we can reassert it. What I would submit is this, that until the change was brought in, there was a requirement as part of the discretionary process that a claimant should establish he has a case strong enough to get over the merits test in order to properly serve a party out of the jurisdiction pursuant to a jurisdiction clause. And my respectful submission is, what is clear from the change, and particularly the minutes, is that there wasn't an attempt to make a substantive change from that position, but rather simply a reform to make the matter easier in terms of cost and time. It wasn't intended to be a substantive change. And it's true the Privy Council case wasn't dealing, as far as I can tell, with a jurisdiction agreement. But there's no suggestion that would make any difference. The point was that the change from a position where you had to seek permission to a change to a situation where you could serve as of right wasn't a substantive difference. It was really simply a procedural change which still required the court to consider the merits. And that's what the Privy Council did in that case. And there is, as we said, my own friend said, there is good policy reasons for that. And we set them out, I think, in our supplemental skeleton argument. And I think the point was captured by my Lord Justice Males, whose observations I would endorse, which is if it's apparent at the jurisdictional stage that the claim is not strong enough to get over the, my Lord called it relatively low, possibly so, but it's still a rigorous requirement, certainly in the commercial court. You have to show a serious issue to be tried, which means that a claim that's not fanciful and has a realistic prospect of success. If you can't get over that hurdle, then the rationale for bringing a foreign party to this country to make a substantive application for dismissal under Part 3 or to bring an Order 14 summary judgment application is contrary to policy and not what the exorbitant jurisdiction, and I shouldn't call it that anymore, but not what the jurisdiction of bringing people to this country is intended to achieve. So, yes, the main point I'm making is that there's no basis properly to say, and the minutes don't assist my own friend on this, there's no basis on which to say that the change in the rules was intended to bring in a substantive change to abolish the requirement in relation to jurisdiction to show a serious issue to be tried. That's essentially exactly, and it is in the bundle, and you may want to look at it, it's essentially what the first instance judge said in the Q8 case. The changes come in, merits are no longer relevant. They're not relevant to jurisdiction. And the Court of Appeal and the Privy Council said that was wrong. And there's no material difference, in my respectful submission, between what was said in that case and what applies here. Unless I can help any more, my Lord, I'll just leave my own friend to deal with one point, which is the 37 point.
Yes, thank you very much indeed.
My Lords, my Lady, very briefly. On my learned friend Mr. Hayne, he drew a contrast between 6.33 and 6.37, and he observes that 6.37, which provides that the permission now does contain a merits test, whereas there is no corresponding reference in 6.33. We obviously accept that, but we say it makes absolutely no difference. It made absolutely no difference in either Sing or in Q8. In Sing, the relevant rule provided for no merits test either. That was held not to matter, and it was held that the merits test did apply regardless. If you want the reference to the rule, it's might give the court the rule. It's Rule 25 in Sing, and it's at Volume 1, Tab 18, page 316. And in Q8, in fact, the Q8 position is even starker, because under the old rules, which were displaced in Q8, the old New Zealand rules, what was known as Rule 50, did expressly provide for an affidavit Lord Lowry described as a merits affidavit. That goes and is replaced with a different rule that contains no reference to a merits test. Again, it doesn't matter. And in Q8, you've actually got the contrast between, it's almost identical to the contrast that Mr. Hayne is emphasising, and in Q8 it simply didn't matter. Those are my submissions on that.
And on one final point, if I may, and I'm sorry I should have made this earlier, as to the timing of the election and how it works. And you may recall I mentioned a case which I'm glad to, I didn't know the reference, but it's a case called Roger Adams against Atlas International Properties. The reference is 2016 England and Wales High Court 2680. Once we can, if it would help, provide you with a copy. It's just important you know at least what the procedure is, as I understand it. Namely that the court isn't prepared to give a draft judgment out dealing with the liability of the agent to the prospective principal and then allow the claimant to say, oh yes, I'll choose that party. What Mr.
The poor old chap
Justice
has to write another judgment.
Well, what Mr. Justice Lavender said, called the parties in and said, I'm now going to go and write my draft judgment. I'm not going to hand it down until you tell me who you're electing, either the agent or the principal.
I know if we're talking about this, my personal experience is the opposite. In that I had a case about election between remedies, that is to say equitable compensation on account of profits. And the judge there handed the judgment down in draft and then required us to elect. And it may well be a matter of the judge's discretion what he does in that respect.
Well, fortunately, we're not in that precise territory. I'm beginning to wish I hadn't asked the question. Well, we will obviously reserve our judgment. We will circulate drafts when available to those whose names have been handed in. That will be on the basis that we are inviting any typographical or other minor corrections, obviously not to re-argue anything, and we will hope and expect that you will be able to agree the terms of an order for our approval in the light of whatever it is that we decide. As you know, the drafts are subject to an embargo, which the court takes very seriously. I think that's all I need to say, other than to thank everybody who has spoken over the course of the last 2 days and the supporting teams who've enabled them to do so. Thank you very much.